Welcome to The Debate. Today, we are exploring the transnational evolution of legal drafting and jurisprudential structures across three distinct legal landscapes, namely the United States, the United Kingdom, and Pakistan.
Yeah, and the text we are drawing from today, Comparative Drafting Texts and Global Jurisprudential Analyses by M. Usman Khan, Advocate, really forces us to confront a fundamental divergence in legal semantics and strategy.
It absolutely does. We are asking a central question here. Is the most effective paradigm for legal drafting the clinical, procedural termination of claims, as seen in the U.S. model, or is it the substantialist, rights-focused plea for sovereign intervention which characterizes the Pakistani and UK Writ petition models?
Right.
I will be arguing that the structural precision, brevity, and procedural exactness of the U.S. and UK models offer the superior framework for modern legal drafting.
And I will be defending the contrasting view. I will argue that the passionate, constitutionalist, and narrative-driven approach of the Pakistani public interest litigation framework represents a more holistic and ultimately more robust mechanism for seeking extraordinary remedies.
So let us begin with the foundational philosophy of what legal drafting ought to achieve. From my perspective, the highest form of legal persuasion is structural brevity. A legal system just cannot function on pure narrative. It requires rigorous, objective filtering mechanisms. If we look at the United States federal model, the ultimate strategic strike against a claim's legal sufficiency is the motion to dismiss under Rule 12b-6.
Sure, the classic 12b-6.
Exactly. For those who might not spend their days in federal court, a 12b-6 motion is basically a defendant's way of saying to the judge, even if everything the plaintiff says in their complaint is absolutely true, the law provides no remedy here. Shut it down now before we spend millions of dollars and years on discovery.
Well, that mechanism fundamentally changes what a drafter is allowed to say, doesn't it? It forces the plaintiff's hand before they even have access to the evidence.
Yes, and that is its genius. It demands rigor up front. Think about the massive shift we saw in the U.S. with the Iqbal and Hohmby Supreme Court decisions. It used to be that a drafter just had to show a claim was possible. Now a drafter has to cross the threshold into plausibility right out of the gate.
Plausibility is a highly subjective bar, though.
Subjective or not, if a claim lacks that plausible factual foundation, the objective is to terminate the meritless case. You request the court to dismiss with prejudice, closing the matter forever. Furthermore, the U.S. operates within a highly brief-heavy culture. Oral arguments at the Supreme Court are famously limited to as little as 30 minutes per side.
Right.
The written drafting carries the entire weight of the argument. It forces clarity over complexity. Therefore, a concise 5-page draft focused strictly on a substantial question of law, navigating clear doctrines like originalism or separation of powers, is inherently superior and far more efficient than a 50-page sprawling narrative.
I come at it from a different way. The fundamental purpose of drafting, particularly when we are looking at constitutional guarantees and sovereign intervention, is to seek justice and extraordinary remedies. It is not merely to act as a clinical mechanism to dispose of cases as quickly as possible.
But efficiency is a component of justice.
Efficiency, yes, but not at the cost of the narrative. When you look at the Pakistani and UK Writ petition models, the draft explicitly requires a narrative history of the grievance, the administrative failure, and the violations of natural justice. You are asking for a writ of certiorari, asking a higher court to review and quash a flawed decision, or a writ of mandamus.
Demanding a public official actually do their statutory duty.
Exactly. You are pleading with the sovereign's representative to right a systemic or specific wrong.
But doesn't that inherently invite emotional appeals rather than strict legal reasoning?
It invites context, which is essential for equity. In Pakistan specifically, the framework under Article 199 at the High Court level and Article 184(3) at the Supreme Court level is explicitly designed for public interest litigation, or PIL. This unique jurisprudential environment rightly allows for passionate, rights-focused language. It is driven by the ancient maxim salus populi est suprema lex. The welfare of the people is the supreme law.
I am familiar with the maxim, yes.
It's a brilliant blend of common law, constitutionalism, and Islamic jurisprudence that recognizes human grievances cannot always be neatly categorized into a 5-page procedural checklist. Ultimately, U.S. drafting assumes the system generally works and just needs efficient filtering. Pakistani drafting recognizes that administrative systems frequently fail and require profound, narrative-driven sovereign intervention.
I see why you think that, but let me give you a different perspective on how we actually manage the volume and validity of those human grievances. This brings us directly to our first major point of contention: standing and access to the court.
Okay.
The U.S. doctrine of standing demands proof of a concrete, particularized injury in fact. Before the court even considers the substantive law, before it looks at the merits of the grievance, the drafter must prove that their specific client has suffered a tangible harm.
Right, the filtering mechanism.
Yes, and it is a brilliant structural safeguard. It filters out abstract, generalized grievances that belong in the legislature, not the courtroom. By demanding an injury in fact, the drafting is forced to be razor sharp. You have to ground the legal argument in empirical reality rather than sweeping philosophical complaints about how society ought to be governed.
Right. But let's look at how that actually plays out in reality. Let's anchor this in a practical hypothetical. Imagine a massive industrial chemical spill that poisons a river system spanning 3 different provinces or states. In the U.S. model, to get through the courthouse doors, your drafting has to find the specific fisherman who lost a quantifiable amount of income or the specific landowner whose property value plummeted.
Yes, you find the aggrieved party.
But if the harm is environmental and dispersed among millions of citizens, finding that perfect injury in fact becomes a massive bottleneck.
Which is exactly why the rule exists, to keep broad, dispersed policy disputes in a legislature, where they possess the democratic mandate to solve them, rather than allowing courts to legislate from the bench.
I understand the theory, but I just don't buy that it serves justice in practice. Let me tell you why that strict procedural filter is problematic when viewed globally. Waiting for the perfect plaintiff while the river dies is a failure of justice.
The river dying is an issue for the Environmental Protection Agency, not a lone federal judge.
But when the agency fails, the court is the last resort. The Pakistani model's approach to locus standi, especially within the realm of public interest litigation, is vastly superior precisely because it is broad. A strict application of the U.S. injury in fact standing blocks the court from addressing massive systemic administrative failures.
It blocks overreach.
In the Pakistani system, under Article 143, the drafting champions fundamental rights by allowing a concerned citizen or an advocate to file a petition representing the broader public interest. It empowers the drafter to use their petition as a bridge between lex lata, the law as it currently exists, and lex ferenda, the law as it ought to be.
And you don't see that as an invitation for endless, unstructured litigation?
No, I see it as necessary. When a drafter is artificially constrained by a demand to prove an individualized injury in a case of widespread constitutional violation, the drafting ceases to be an instrument of justice and becomes a victim of its own procedural rigidity.
That's an interesting point, though. I would frame it differently. The rigidity you criticize is exactly what prevents the judiciary from overstepping its bounds and usurping the executive. When a drafter leans into the American style, utilizing something like an amicus curiae or friend of the court brief to influence broader policy, they still do so within clearly defined parameters of constitutional validity and federalism. But let us move across the Atlantic to look at the philosophy of pleading from the perspective of the United Kingdom, which perfectly illustrates the power of precision over narrative sprawl.
The UK is an interesting middle ground here.
It is, and it heavily favors structure. The UK system is highly disciplined, guided by the Civil Procedure Rules, or CPR, and their overriding objectives to deal with cases justly, but also at a proportionate cost. They operate with a bifurcated legal profession.
Solicitors and barristers.
Precisely. Solicitors draft the initial pleadings, doing the ground-level fact-gathering, and then barristers refine those arguments into highly focused points of law for the court. Over the past few decades, the UK's plain English movement has aggressively stripped away archaic legalese and emotional storytelling in favor of pure objective clarity.
They certainly have.
To quote the source material directly, "The law is a profession of words. Choose them with the precision of a diamond cutter. A diamond cutter does not leave rough edges of emotional narrative. They cut away absolutely everything that is not structurally necessary to reflect the light of the law.
That's a compelling argument, and I acknowledge the immense value of precision. The UK's move away from archaic legalese is certainly a positive evolution. No one wants to read herein before and to wit 50 times in a document.
Exactly.
However, have you considered the reality that the complexity of justice often resists simple categorization? The intellectual task required of a drafter in Pakistan involves a far more sophisticated philosophical balancing act through the doctrine of harmonious construction.
How does that prevent the draft from becoming bloated, though?
Because the complexity is necessary to the jurisdiction. When you are drafting in a system that features strict binding stare decisis under Article 189, meaning lower courts must absolutely follow Supreme Court precedent, while simultaneously balancing statutory law, robust constitutional guarantees, and the injunctions of Islam overseen by the federal Sharia court, you cannot simply be a diamond cutter.
You
must be an architect of synthesis. If an administrative statute seems to conflict with a constitutional right or an Islamic injunction, the drafter cannot just coldly cut one away. The draft must meticulously demonstrate how these overlapping legal frameworks can coexist without rendering any of them redundant.
But that inherently leads to...
It requires a substantialist narrative. It requires the drafter to weave a deeply reasoned argument that harmonizes disparate sources of law. That is a fundamentally richer and more complex form of drafting than relying strictly on the clinical transactional exactness of the UK model.
I hear you, but I am not convinced by that line of reasoning because the attempt to harmonize vastly disparate sources of law often leads to exactly what I am warning against: sprawling, unfocused petitions that lose sight of the core legal questions.
I wouldn't call them unfocused.
If you are trying to weave 5 different jurisprudential frameworks together, the judge has to wade through dozens of pages before understanding what the actual violation is. This brings me to our third crucial area of debate: how we handle time, delay, and the structural approach to appellate review.
Okay.
One of the most critical professional growth areas identified in our source material is the adoption of the US and UK standard of review framework.
The standard by which an appellate court judges the lower court's decision.
Precisely. In Pakistan, there is a noted tendency for drafters to simply re-argue the entire merits of the case on appeal. They retell the whole story from the beginning, essentially treating the appellate court like a second trial court.
Well, they want to ensure the context isn't lost.
But it's procedurally improper. By contrast, a sophisticated advocate recognizing that drafting is architecture will frame the appeal exclusively around the standard of review. Did the lower court commit a clear error of law? Was there an abuse of discretion in how they applied the facts?
Right.
Framing the draft around these highly specific procedural benchmarks is infinitely more professional and persuasive than drowning the appellate court in a 50-page relitigation of the facts. It respects the hierarchy of the courts, it conserves judicial resources, and it forces the drafter to identify the precise structural failure of the previous judgment.
I fully agree that global benchmarking adds immense weight. Certainly, an advocate who can correctly cite a UK House of Lords decision or a US Supreme Court ruling on a principle of natural justice strengthens their petition immensely. But you cannot divorce procedural benchmarks from the human context in which they occur.
Context cannot override procedure.
Let's look at equitable doctrines regarding time and delay. Under the U.S. system, a statute of limitations issue is often raised in that exact 12b-6 motion to dismiss you praised earlier. It acts as a fatal clinical blow. The clock ran out, the case is over.
Which provides necessary finality and predictability for defendants.
But at what cost to substantive justice? In the Pakistani and UK writ systems, we rely heavily on the doctrine of laches. This is grounded in the maxim that justice delayed is justice denied, but it operates as an equitable dialogue.
Meaning the petitioner has to explain the delay.
Exactly. If there is a delay in seeking a writ, the drafter must explain it immediately in the petition. Explaining the context of a delay, perhaps a petitioner was navigating a labyrinthine administrative state, or they were actively misled by a government official, or they lacked access to resources. is just as crucial as meeting a procedural benchmark.
But that turns the court into an arbiter of excuses.
No, it allows equity to survive alongside strict procedure. You cannot simply discard a fundamental rights violation just because the clock ran out without first hearing the narrative of why the clock ran out. That is where the passionate, rights-focused drafting model proves its worth. It treats the court as a forum of conscience, not just a processing plant.
True equity is predictable, not entirely dependent on the specific conscience of the judge hearing the case that day. When a legal system relies on flexible stare decisis, as the U.S. often does, treating precedent as persuasive rather than strictly binding in certain constitutional contexts, it requires the drafting to be extraordinarily disciplined.
Disciplined, yes, but
If you are going to challenge established precedent, your brief must be rooted in rigorous, universally applicable doctrines, whether that is legitimate expectation, promissory estoppel, or separation of powers. It cannot merely be an emotional appeal explaining a delay.
I wouldn't call it merely emotional.
The discipline of the brief-heavy culture means that the written word alone must carry the day. When you strip away the days-long oral arguments that are common in jurisdictions like Pakistan or India, you elevate the drafting to a science. It becomes a standalone instrument of logic that can be scrutinized, tested, and applied objectively.
I understand the appeal of predictability, but drafting can never be reduced entirely to a science devoid of its social mandate. When we look at the highest courts across these jurisdictions, their fundamental focus dictates the drafting style you are talking about.
How so?
Well, the UK Supreme Court focuses on the interpretation of statutes and common law points of general public importance. The US Supreme Court focuses heavily on constitutional validity and federalism. But the highest courts in Pakistan must act as the ultimate sentinels of fundamental rights and Sharia compliance.
Right.
The drafting must therefore be substantialist. It must constantly invoke constitutional guarantees because the stakes are often deeply tied to the basic welfare and survival of the citizenry. The drafting is a living, breathing plea for intervention.
But brevity?
Yes, brevity is a modern trend across all three jurisdictions, and no one is arguing for wasted words. But brevity should not come at the cost of erasing the narrative history of an administrative failure that has crippled a community.
Erasing the narrative is not the goal. Distilling the narrative to its legally actionable essence is the goal. If a community is crippled by an administrative failure, the most effective way to help them is not to write a novel about their suffering, but to immediately summarize why the law does not support the administration's actions.
But the novel, as you call it, establishes the severity of the breach.
The introduction and statement of issues must be an immediate summary. Citing an excess of jurisdiction or identifying errors apparent on the face of the record is what actually moves the machinery of the court. The prayer clause at the end of the petition must be a specific request for a direction, order, or writ, not a vague plea for harmonization. Precision is what ultimately holds the sovereign accountable, because precision leaves the administration no room to hide behind rhetorical ambiguity.
But precision without context can easily become a tool for dismissing valid grievances on technicalities. That is the danger of the U.S. 12b6 model when applied too broadly, or the Iqbal plausibility standard.
It prevents fishing expeditions.
It allows well-resourced defendants to terminate claims before discovery even begins, simply because the plaintiff's drafter couldn't meet a highly subjective standard of plausibility without access to the defendant's internal documents. The UK and Pakistani focus on natural justice violations inherently requires the court to look slightly deeper to ensure that the process itself was fair before shutting the courtroom doors forever.
We have unpacked a considerable amount of complex jurisprudential theory today, tracing the tension between the architectural rigidity of the West and the harmonizing narratives of the East. As we move to summarize our positions, I maintain that embracing brevity, clear doctrines, and procedural boundaries ensures that legal drafting acts as a precise architectural framework for justice.
Whether it is applying the strict scrutiny of a motion to dismiss, relying on the bifurcated precision of the UK's barristers and solicitors, or insisting on a strict standard of review on appeal, objective structure is what guarantees consistency in the law. Without strict adherence to concepts like originalism or clear separation of powers,
drafting becomes dangerously subjective, and courts drift away from adjudicating the law into dictating public policy.
And I maintain that while precision is undeniably necessary and an advocate must be clear to be persuasive, legal drafting must ultimately remain a sentinel of fundamental rights. A system that elevates procedural termination over substantive justice risks losing its legitimacy with the people it serves.
I see that perspective.
The Pakistani and UK Writ petition models, which accommodate the necessary narrative of administrative failure and allow for broad public interest litigation, ensure that the law remains capable of addressing complex societal needs. Harmonious construction and a commitment to salus populi est suprema lex are what allow constitutional evolution to flourish and ensure the courthouse doors remain open to those who need sovereign intervention the most.
Yet, despite our different approaches, there is a clear point of convergence in the material. Both of us must acknowledge that any modern advocate operating at the highest levels must master comparative jurisprudence. The fundamental legal maxim, legis posterioris praeries contrarius abrogant, later laws abrogate earlier contrary laws, is a universal truth.
It absolutely is.
It forces drafters in Washington, D.C., London, and Islamabad alike to constantly adapt to legislative evolution and cross-pollinate their strategies.
Absolutely. Understanding how a writ is constructed in London or Pakistan compared to how a brief is filed in the United States refines an advocate's ability to be globally persuasive. It teaches a drafter when to be a diamond cutter and when to be an architect of synthesis.
We will leave it there. The source text leaves us with a profound closing reflection from ancient jurisprudence. Justice is the constant and perpetual will to allot to every person their due. There is certainly much more to explore regarding transnational legal semantics within this material, and we encourage our listeners to dive deeper into these comparative drafting texts.
Thank you for joining us as we unpack the architecture of the law.
Until next time.